Good morning, Your Honors. The matter before the court this morning is the case entitled William Pettersen v. Monaghan, Safar, and Ducham, docket number 20-192. Appellant William Pettersen is self-represented. Representing the appellee, Monaghan, Safar, and Ducham, is Eric David Jones.
Okay, thank you very much. Mr. Pettersen, can you hear me?
Yes, Your Honor, thank you.
All right, please go ahead.
Good morning, Your Honors.
Good morning.
It's an honor to speak before you today. I'm Attorney William Pettersen, representing myself pro se in the case. May it please the court. This case involves an alleged breach of compensation promise and a resulting termination after the prospect of legal claims was raised. This argument today will briefly address the first element of promissory estoppel, and thereafter will attempt to focus the majority of the time on the issue of public policy termination, as it appears to be the most important legal issue in the case. Regarding each of these issues, I will attempt to provide some additional arguments not discussed within the briefs. Regarding promissory estoppel, a promise is defined as a manifestation of intent to act or refrain from acting in a specified way so as to justify a promisee in understanding a commitment has been made. That is exactly what occurred in this case. The alleged promise in this case is a statement made by defendant's managing partner, Attorney Monaghan, to plaintiff during salary negotiations in 2016. It's worth noting these individuals had engaged in prior negotiations in which plaintiff had requested additional compensation and in which Attorney Monaghan had declined, but had communicated plaintiff had an opportunity to earn partnership in the future with the firm. During the meeting in question, plaintiff approached Attorney Monaghan and communicated he was still uncomfortable with the level of his compensation and was unwilling to remain employed with the firm unless a more specific compensation plan was reached. Importantly, Attorney Monaghan then asked plaintiff what he was requesting. Plaintiff then proposed a compensation plan, as set forth in the briefs, that was both specific and definite in nature.
Your original compensation plan was in writing, was it not?
That's a great question, Your Honor. There were no, in I suppose my view, there were no employment contracts written. There was a letter of hire that set forth the salary generally, but there were no written contracts as to any compensation plan, in my view.
And so, having said that there was something in writing about your original compensation, why didn't you request something in writing here?
Thanks for the question, Your Honor. Another great question. The thought that comes most quickly to mind is that once you hear something that's a good answer, you don't try to change anything thereafter. I received what I perceived to be an acknowledgement and an affirmation of the compensation plan that I had proposed, and I did not want to rock the boat anymore after I received what I had asked for.
Well, Mr. Pettersen, the what you received was a confirmation that what you were asking for was reasonable. Isn't that what you got?
That is what defense argues, Your Honor. The issue about
he said something different than that?
Yes, Your Honor. I interpret. I believe the exact words were, "Yes, that's reasonable." After the compensation plan was proposed, I believe a reasonable interpretation of that is, yes, that's reasonable means yes. that the proposal is reasonable. And I believe a reasonable jury could find that when that's being proposed and Attorney Monaghan knows plaintiff has said he needs a specific plan in order to remain employed with the firm, when he says, yes, that proposal is reasonable, that's an affirmation of the plan.
You spent a lot of time in your brief talking about how you interpreted this statement, but one of the claims that you have here on appeal is a fraud claim that requires intentional misrepresentation. I don't understand how you can, on the one hand, say this is all, we should look at this as how you interpret it, when a fraud claim requires intentional misrepresentation.
Understood, Your Honor. The way I would most quickly address that question, I think, would just be to say that a promise under promissory estoppel does not require intent at the time by the promisor not to follow through with the promise. The promisor can make a promise that he or she really intends to make good on, and then later, by happenstance, accidentally break it, and that's promissory estoppel. The difference simply is the intent at the time the promise is made. Under intentional misrepresentation, there needs to be sufficient evidence that at the time the promise was made, the promisor did not intend to make good on the promise.
So do you say that there was a definitive statement or a promise that was made specifically, or just this is an option for you?
A definitive promise, Your Honor, and the specific language would be yes, that's reasonable. The affirmation of the compensation plan during that meeting.
With what parameters, though? If you a 5-year partnership track with a $100,000 salary, was that based on anything, including like you driven, bringing clients into the firm, or anything at all regarding what your contributions would be to the firm?
I had previously been told that I did not need to bring in clients in order to obtain partnership. But the specific parameters of the compensation plan were simply that my performance up to that point, which had been deemed satisfactory, would continue. That as long as my good performance continued, this is what the trajectory would be.
Good performance in your work product, or good performance in your billable hours?
I think that was very much in the employer's discretion. However, it was a standard. Oftentimes, contracts have compensation plans that don't even have a performance metric. So I think this is similar to many contracts and agreements in that respect.
Are you disputing that you are an at-will employee?
I don't think this created any just cause termination requirement, Your Honor. So I don't think that this promise would change the at-will nature of the employment.
On that issue, I know, I'm sorry we're jumping at you with all these questions. You said you wanted to talk about wrongful termination, the public policy issues, but I'm having a hard time finding in the record anything to support your notion that there was a statement to you, you're fired, you're done. I know you didn't file a motion of contested facts or uncontested facts. And so as I understood it, the trial court said that it would just look at any documents that might establish facts. But what is the evidence that you're saying indicates that you were fired? Are you suggesting someone actually said you're fired, leave today, pack up your stuff?
Yes, Your Honor. I believe that that will be in my statement of facts, which is printed case 220 through 232 and 233. And the termination should be set forth therein. There was a letter that was provided that stated if I was not quitting, I was terminated. And there was also a statement made by Attorney Monaghan in a meeting with myself and the partners to that same effect.
Thank you.
I suppose I will skip to the unjust, termination and violation of public policy, and focus the remainder of my time on that. If there aren't any other questions at this time. The brief set forth certain arguments on the policy. I will just today provide additional arguments in support of the public policy at issue. First, the Vermont Constitution, Chapter 1, Article 4 states, and I'm paraphrasing, that every person within the state shall have remedy and recourse under the laws freely and without being obliged to purchase it. And there's a comma between freely and without being obliged to purchase it, which indicates freely means more than just without being required to pay money. Otherwise, it would be a redundant clause. So if freely means more than the loss of money, it should certainly include a loss of one's employment, as that's one of the greatest economic costs a citizen can suffer.
But you're,
Mr. Pettersen, don't we require a showing of cruel or shocking conduct in order to agree with you? That's the Boynton case in 2014, 2019, somewhere in there.
Your Honor, I certainly, that sounds correct. I trust Your Honor is correct. I would submit that that connotation often has a personal nature to it. So I think it's just a little bit difficult to expand that to public policy issues. But in general, the age discrimination, for example, that this court found was violative of public policy before it was a statute. That is similar in this respect in the fact that it affects many people and at a large scope. And I would argue the loss of the ability to freely bring legal claims is indeed rising to that level of unjustness.
So, Mr. Pettersen, can I ask you a question? You, as I understand it, now have a law practice yourself. Is that right?
That's correct, Your Honor.
And let's say that your business grows and you someday hire an associate. Is it your position that if you had an associate and the associate said, counsel, I don't like the way things are run around here, I'm bringing a lawsuit against you, that you would not, as the employer, have the ability to discharge that person at that point?
Great question, Your Honor. I think the standard would simply be what it is for other claims similarly, which is a termination could still occur for any other reason, just not retaliation. So any legitimate non-retaliatory reason would be fair for termination.
but your position as an employee at will, that it has to be some justification for the termination?
An employee at will, there needs to be no justification, Your Honor. So it would be any legitimate non-retaliatory reason. And I suppose you're right. It could be, this would be different maybe. It would be just any reason, just not retaliation. That's a great point.
What?
At this time, I would reserve the rest of my time if I may.
All right.
Thank you.
Okay, we'll turn to the appellee. Counsel for the appellee, please introduce yourself, identify your client, and then proceed.
Thank you, Mr. Chief Justice, and may it please the court. I'm Eric Jones, and I represent Monaghan, Safar, Ducham, PLLC, the appellee in this case. The trial court got it right. The trial court properly granted summary judgment for several reasons. First of all, despite Mr. Pettersen's failure to completely comply with Rule 56, the court did consider all evidence submitted by both parties. Second, reviewing the evidence submitted by both parties, the court properly found that there was no dispute of material fact, and that is not even the appellant's argument on appeal. And applying established legal principles, the court found that the firm was entitled to judgment as a matter of law on each of the 4 claims asserted. And this court should affirm. At its core, this case is a simple compensation dispute. And the entire case rests upon a single, otherwise unremarkable conversation between Mr. Pettersen and his supervisor, attorney Brian Monaghan. In this conversation, which was many in which Mr. Pettersen complained about his compensation, Mr. Pettersen did express his hopes and aspirations for his career future at the firm. According to him, he explained that he thought a reasonable trajectory for himself would be one in which after 5 years, he would be a partner earning $100,000 a year. And according to the plaintiff or the appellant, attorney Monaghan responded by saying, I think that's reasonable. That's it. There really is no more to this case. That is the entire factual foundation of Mr. Pettersen's claims. But these facts completely fail to support a single cause of action. Mr. Pettersen points to nothing that is actionable. Now, I'll focus on the details in a moment, but at the outset, I submit to the court that the 4 claims appellant asserts fail for the following reasons. The promissory estoppel case and the fraud claim, with the exception of the fact that fraud requires a showing of actual fraudulent intent, has a much higher bar, they're both essentially the same claim, which is that Mr. Pettersen believes that he was induced to stay at the firm by a representation that Mr. Monaghan made. But both claims fail at the outset because the statement that Mr. Pettersen attributes to Mr. Monaghan was clearly a mere expression of judgment, opinion, aspiration that cannot support a cause of action as a matter of law. Second of all, Mr. Pettersen did not rely to his detriment on a single thing anybody at the firm did or said. Throughout his entire career at the firm, he was always looking for the exit door. The only reason he didn't leave was because he didn't get a better offer, but he didn't stay because of any inducement by what Mr. Monaghan supposedly said. Finally, with regard to these 2 claims, the alleged statement concerns a state of facts 5 years in the future. We will never know whether or not Mr. Pettersen ever would have met his aspirations because he quit 3 years before these events were supposed to have happened. So he can't quit after only 2 years and then run to a court seeking a remedy for some trajectory about what should have happened 3 years from now. With regard to the unjust enrichment claim, frankly, that can be dismissed in short order. Mr. Pettersen was compensated very well for his services. And on top of his originally agreed upon salary, he received pay raises and $13,000 of bonuses. He cannot claim there's an injustice here. And then finally, with regard to the public policy claim, first of all, Mr. Pettersen, the facts demonstrate he resigned his job. And in fact, there is no evidence in the record that anybody said, you're fired. He quit. The firm documented his resignation in a letter, which alternatively said, to the extent you didn't quit, you are hereby terminated. But there was no grand statement, as he mentioned. More importantly, there is no public interest implicated by this case. This case is the epitome of private contractual disputes between 2 parties that does not implicate any public policy whatsoever. Now, I did want to just very briefly touch on a procedural issue in the case, which was that in response to our motion for summary judgment, where we properly supported the motion with a statement of material undisputed facts, Mr. Pettersen did not respond at all to that statement. He just ignored it. So, I mean, literally, the facts presented by the firm were undisputed. And the court properly deemed the facts undisputed. But this is not any kind of gotcha type of procedural argument, because the court did nevertheless explicitly state in its opinion that it considered record evidence submitted by the appellant. And I don't think the court limited its consideration to just documents. I think the court considered any kind of record material submitted, but the court did not accept the conclusory statements. Yes.
Other than it creating a housekeeping issue for the trial court on what was or wasn't contested, did the lack of compliance with Rule 56 play any part in the outcome here?
No, other than to highlight that the facts really are not disputed, and there's nothing that warrants a jury resolution in this case, factually. And that being said, I will move on to the legal merits of the case. With regard to promissory estoppel, it is, as Mr. Pettersen mentioned, an essential element that there be a specific and definite promise. There is nothing in the record in this case that shows that the firm made a specific or definite promise. There was nothing promissory at all. There was simply an expression of judgment that Mr. Monaghan felt Mr. Pettersen's hopes were reasonable. That's not promissory. It's not an inducement. It's not a misrepresentation. So we submit that is simply, as a matter of law, inadequate to float the claim. But also, I want to get back to what I mentioned in my introduction, which is that there is no evidence whatsoever of detrimental reliance. The record actually shows that Mr. Pettersen was actively engaged in a job search for the 2 years that he was working. So he did not refrain from continuing to seek other opportunities. His statement of facts refers to a plan he had that, but for the job at Monaghan, Safar, Ducham, he might have looked for jobs out of state. But the materials he cites in his statement do not refer to a plan at all. There was no plan to leave the state. To the contrary, the only evidence of Mr. Pettersen's career plan was to return to Vermont. He was a Vermonter who came back after a clerkship in Nevada, to return to Vermont for work. That's the only plan we have in the record with regard to what his career plan was going to be. More importantly, after he quit in early 2018, there's no evidence that he actually looked for work out of state. The alternative to working at the firm was he set up his own law firm here in Vermont, where he has stayed ever since. So his self-serving statement that he might have looked for jobs out of state is, again, wholly inadequate to support a claim of detrimental reliance, which under this court's rulings requires a substantial and material change in position. We contend that the appellant has no evidence whatsoever that he materially or substantially changed his position with regard to anything. With regard to the fraud claim, I want to go back to Justice Carroll's question about, doesn't that require showing a fraudulent intent? Yes. And there's no evidence anywhere in the record in this case of fraudulent intent. Not to mention the fact that fraud would also require a showing by clear and compelling evidence. So he fails not only for an insufficiency of evidence, but also could not possibly meet that standard of proof. There simply was no representation of fact, much less a misrepresentation of fact. And again, like with the promissory estoppel claims, there's no evidence of detrimental reliance that would be necessary for a fraud count. And furthermore, again, he inflicted his own harm to the extent his aspiration for was something that could happen 5 years in the future, and he himself quit after only 2. With regard to the unjust enrichment count, frankly, I don't understand it. I never did. Mr. Pettersen was paid handsomely and clearly at market rates for his services. He started at $55,000 a year. He was earning $70,000 in the second year of his employment. That is a solid compensation package here in Vermont for his services. So to suggest that somehow the circumstances here are so inequitable and so unjust that an additional award is just untenable.
Mr. Jones, could you conceive of any possibility of an unjust enrichment claim from an associate to a law firm where something would occur that would allow that type of cause of action to occur?
Not when the services that are being provided by the associate are within the scope of services contemplated by the parties with the job. And by that, I mean, there's a case that I believe Mr. Pettersen cited. It wasn't in a law firm setting, but I think the principles would apply. But the employee actually was asked to do something above and beyond, wholly different from what they were originally hired to do. Expected additional compensation for the additional services, but that's not the facts of this case. An associate attorney who was brought on to provide associate assistance to the firm's partners who only does that scope of work and no more than what was contemplated by the parties, and is in fact compensated as agreed, then no, I don't think there can be an unjust enrichment case in that situation. Moreover, Mr. Pettersen's argument at one point, it sounds like he's quite literally saying that receipts that are earned by the firm on his time that exceed the salary he was paid is somehow money that he's entitled to under an unjust enrichment plan theory. Clearly, that's not how law firms work. That's not capitalism. That's not the law. And then finally, with regard to the public policy count, the claim is essentially wrongful termination. But we submit Mr. Pettersen was not terminated. He resigned. Now, I know he says, I didn't intend to resign in a self-serving argument before this court. But the facts are the facts. And the undisputed facts in this case are that he decided after getting a raise in March 2018 that he was sufficiently insulted and he had to leave. He then contacted representatives of Westlaw and Lexis to set up his own accounts, telling the representatives that he was exploring opening his own firm. He then set out to copy client files off the firm's client data service systems. He then also copied all of his emails, all of his calendars, and his contact information for his entire time at the firm. He then issued written notice to the firm in which he said, I must now find a job at another firm. Later that day, in a meeting with the partners, when asked whether there was anything that could be done for him to stay, he said, there is no way I can stay. And he confirmed that he was looking for other work. Those undisputed facts clearly establish that he had resigned his position, that he took the steps to end the employment. Having resigned, he doesn't then get to decide, I'll leave when I find another job. The firm has every right to say, well, you're resigning, we accept your resignation, and we accept it as of today. And that is not wrongful termination. Even if, as part of that resignation notice, the appellant, as in this case, suggests a severance payment and offers in exchange for the severance payment a release of claims. That does not implicate public interest.
But even if he had been fired rather than resigned, are you conceding by your argument that that would be wrongful at that point?
Not at all. I'm simply establishing that the facts of this case, we don't even get to public policy because he did resign. But even if this was a termination, he were to say, I think I have these claims against you, and the firm were to have said, well, in that case, you're fired. That does not violate public policy. Now, it
could violate public policy if he had certain information that would be detrimental to the firm on the way they were doing something that is retaliatory. I mean, that is a possibility.
Fair point. There's a category of claims that are specifically protected, like the claim you just mentioned there, or discrimination claims under the Fair Employment Practices Act, which explicitly, as a matter of statute, say that you cannot be retaliated against for asserting claims under the statute. But for a common law claim to compensation, which is this case, I would say no. And in fact, the prior cases from this court suggest as much. Two examples of cases where the court found that it was merely private contractual rights at issue were assertions to vacation pay or sick pay before there was a statute. Those claims were found to be not implicated. Threats of making those claims were found to be not enough to support public policy. Refusal to sign a non-compete agreement was private and contractual, not public policy. To arise to the level of public policy, there needs to be some collateral public interest. In the whistleblower example you just gave, Justice Cohen, that would be an example of a collateral public interest that's also in play. Or, for example, the case where this court
have to wrap up your argument.
I see that I'm out of time, and I apologize. I will conclude. For these reasons and the reasons stated in our brief, we believe this court should affirm the trial court. Thank you.
Thank you very much. How much time do we have, please?
Appellant has 1 minute and 30 seconds remaining.
All right, counsel.
Thank you, Your Honor. again, I will rely on my briefs for most claims, and I will attempt to focus the remainder of my time on the public policy issue. I will speak quickly and just try to get out some additional arguments for the court's consideration. The Vermont Fair Employment Practices Act and other statutes have retaliation provisions long-standing in the state. And not only does this show the public policy, it also would be bolstered if a common law exception were also found, because the uniformity would help employees better understand that they had protection under the law. And this would decrease the chilling effect not only in the common law, but also the statutes, helping those statutes have more effect. Additionally, the economic considerations also lean towards this public policy, as if employees feel more able to enforce agreements with their employers, they will be more willing to enter into agreements with those employers, and that will increase the economic efficiency of the employer-employee relationship.
Do you have any case that says that? Or, I mean, isn't that,
Just-
you get terminated for not getting paid what you think you're worth, or you leave because you're not getting paid for what you're worth. Isn't that a sufficient basis under any circumstance where it's not retaliatory, other than the fact that you are dissatisfied with the compensation package?
If I understand your Honor's question correctly, my argument on the policy is simply that an employee is fearful for termination, is going to be less willing to enforce any agreement they enter into with an employer for fear of losing their job. So if there's an exception under public policy, then employees will be more willing to enter into agreements with their employers because they will feel they can enforce those agreements.
All right.
And it
Thank
looks
you
like
very
I'm
much.
out of time.
Thank you.
Thank you,
very
Your
much.
Honors.
Thank you both for your arguments. Please call a conclusion of the hearing.
The next hearing for the court is scheduled for 2 p.m. this afternoon.
Okay. Thanks to both of you. Thank you.
Bye, thanks.